Okay, so today we'll talk about wills, powers of attorney, and estates. It is highly recommended that we should always have our wills ready and up to date. We get busy and do not get around to getting our wills in order. If there is no will, there will be issues for the family while they are grieving from the loss of a loved one. Also, this topic is not only for the elderly. Even young adults should have their wills prepared and updated regularly. Our speaker today is Mr. Muhammed Datoo. Mr. Datoo is a senior wealth advisor and senior investment advisor at BMO Nesbitt Burns, which is part of the Bank of Montreal Group, one of the largest banks in Canada. He has been with the firm for over 25 years, and during this time, he has been helping individuals and families in various areas of financial planning, investment planning, tax planning, as well as estate planning. Mr. Datoo, we look forward to your presentation. Over to you. Unmute yourself first, please.
Assalamu alaikum, everybody. Nazmul, thank you for that very kind introduction. Once again, my name is Muhammed Datoo, and as Nazmul mentioned earlier, I'm a senior wealth advisor at BMO Nesbitt Burns, and I have been in that role for close to just over 25 years now. I want to begin first by thanking all of you for giving me the opportunity to speak to you today, taking time out of your Sunday afternoon. And the topic that we're going to discuss today is somewhat of a difficult topic for a lot of people, because we're actually talking about getting your affairs in order before you pass on. So some people, some people get a little bit uncomfortable with this, but as Nazmul mentioned earlier, that it is highly recommended in our religion to have our affairs in order, so that our loved ones, once we are gone, are able to to sort out the wishes that we have. So we're not going to get into any kind of the presentation that I've made today is designed more for Canadian, a Canadian resident and Canadian law, but the principles can be applied pretty much in any country. And we're not going to be touching on anything Islamic related. So this is not a presentation on Islamic wills. That is not my expertise. So that we will just focus on just the general concepts about the will, powers of attorney, and estates. So before, again, I go over, I just wanted to, I'll switch over to the next slide, which is a disclaimer, which will just get the legal stuff out of the way. The opinions expressed in my presentation are my own and are for general information purposes only. I encourage you all to consult a tax advisor, legal professional, for any issues that may directly impact you. Sorry, I just had some people that were off mute, so it threw me off a bit. That's if you can all just put yourselves on mute, that'd be much appreciated. So again, I'm not a lawyer. I'm not an accountant. What I am in my role is, I give you the information based on the different people that I speak to and my experience, and then I will always instruct my clients to go in and talk to these professionals who are more in tune on how to prepare the various documents. So the three topics, or the three key things that we'll touch on today, number one is we'll talk about wills, powers of attorney, estates, and probate. I'll try and keep it fairly simple without, we'll try and avoid some of the big legal terminology that's in there, so you have an understanding of these three concepts. So let's just jump right into a will first. What is a will? A will is a written document that speaks for you after you die. So once you die, you're unable to speak, obviously. So this is the document that will actually speak on your behalf. It will outline your wishes and how you would like to distribute your estate. And then you get the question, what is the estate? Your estate is basically all of your assets and liabilities once you pass. What are the different types of wills? So the two common types of wills, one is a handwritten will, which is also known as a holographic will. And the second one is one that is being prepared by a professional. Now, in my professional opinion, I highly, highly recommend that you get a will that is prepared by a professional and you avoid going with the handwritten one. Um, what happens with the handwritten will sometimes is it may pose some challenges when you go in and take that will and try and present it to a financial institution. There could be certain challenges. So I'll give you an example. At the banks, it might involve taking that will and going in and hiring a handwriting expert to prove that it is actually your writing, and so on and so forth. So for the most part, you want it prepared in a professional manner so that you avoid any of those issues that may come up down the road. Um, why is it important to have a will? Well, it is one of the most important documents that you will need in this world after you die. So once we die, we take our other book of deeds with us in the afterworld. But in this world, it is this document that now becomes one of the most important documents. So, like I said earlier, you won't be around to say anything. So it will be this document that will be doing the talking for you. The other more important part is most financial institutions require a will in order to distribute the estate to your beneficiaries, and we'll touch into that in the next couple of slides. Um, so, what are some of the items that are contained inside your will? Number one, it will outline what your wishes are and how you want your estate distributed. It will have the names of your various beneficiaries, and it will have the name of your executor. Now, I will again go in and touch on each of these concepts or each of these points in more detail. So first of all, let's go into what is a beneficiary. A beneficiary is a person or persons or entities for that matter that you will name inside your will who will be receiving the property from your estate and the portion of that property. It can be your children, it can be your parents, it can be charities, it can be friends. There's no limitation as to who you can leave your property or estate to. Who is the executor? Well, the executor is a persons, company that you will name or appoint to handle your estate once you pass. Okay, so the executor is going to be somebody that is going to fulfill the responsibility. It is his or her responsibility to fulfill the wishes that you have outlined in the will, settle your overall estate, such as distribution, disposal of assets, and ensuring your final tax return is submitted. So remember, we've so far said in your will, you're going to have the names of beneficiaries and you're going to have an executor. In most cases, the executors are the beneficiaries, but they can be different. Okay. So what the executor's role basically is to go in and say, okay, you're appointing the executor to go in and handle this estate on your behalf. And these are some of the duties, like I've outlined below: the distribution of the assets, disposal of assets, and your final tax return. So in Canada, one of the requirements that your executor will have to do for you is once your estate is settled, you're required to file something called a final tax return. And once that is filed and accepted by CRA, they close your file and that's it. You're done. Kudafis, the file is closed and everybody moves on. Um, if you have named an executor in your will, one of the things that you want to make sure is that you confirm with them that they're okay with taking on the task of executor. Very often we come across cases where an executor is named and they might not even be alive at that time. So it hasn't been updated, and all of a sudden, the person that's supposed to actually go in and execute on the will is not around himself or herself. The other thing you want to really do is you want to make sure if you're going to name somebody as an executor, then that they are okay with you naming them, right? Because I'll give you an instance. Suppose I go and name somebody and I don't tell them, I pass away, and all of a sudden my will is open and it says, okay, Mr. So and so is my executor. They're like, well, you know, I'm not comfortable with doing this, so I'm not going to do it. And very few people know this, but your executor has the right to reject the role. And if that happens, then the courts will appoint an executor for you. So very important, if you're going to name an executor, first go and check with that person that, look, I would like to name you as an executor in my will. Is it okay? Are you able to handle that task for me, right? And if they say yes, we're able to handle it, then you can go ahead and put their name inside. So we'll touch base now on the next part, which is probate and probate tax. Number one, and here we're going to talk about three things. Number one, what is probate? What is probate tax? And why is probate important? So probate is basically the formal approval by the court that this is your last will and testament. So once you pass, your will is opened. There's a probate process whereby there'll be a tally of all of your assets that are listed, and this is then submitted to the courts, and the courts will take the will and they will probate it, right? And what that does is it says it confirms that this is Mr. So or Mrs. So and so's last will and testament, and then they will release the will back as a probated will. Once the will is probated, it has confirmed that this is now your last will. There's no other wills that are floating around out there, so nobody can come in and challenge that will after that point. Now, for that process to take place, unfortunately, I say unfortunately because there's a tax involved and in Canada, and it's called probate tax. Now, probate tax is also common in many countries. I know it's common in Europe. It's common in parts of Africa. I'm not sure about the Middle East, but in these two regions, it is something that is very common. So probate tax is actually a tax that you have to pay on your estates once it goes through that probate process. In Canada, it's about 1.5% on your overall estate. There are certain things that are exempt from probate. Now, I won't get into those. So what I will suggest in that case is that for those that have a very large estate, so if you think you're going to have a large estate, then I encourage you to reach out to your financial advisor, your tax advisor, or your legal advisor, and explore the possibility of minimizing the amount of probate tax. Now, you might not totally be able to avoid paying the probate tax unless again, I don't want to get into those technicalities, but you can certainly use some strategies to minimize the amount of probate tax, right? So I urge you in that case to go in and reach out to your advisors, whoever you're dealing with, and let them know that you're concerned about, or you want to have a discussion on probate tax, and how you can go in and minimize the impact when it comes to your turn. Um, the next point is basically why focuses on why it's important to go through the probate process. A lot of institutions in Canada will not allow the distribution of an estate to take place without the will being probated. Now, that is mainly, it's not a one-sided game. It's mainly for the protection of the financial institution. So what has happened in the past is somebody goes in, so let's just say something happens to me. My family goes in with a will to the bank and it's not probated. The bank goes in and distributes the assets that are in the account. And 2 years later, somebody else shows up with another will and says, oh, but this is another will. So what that does is it goes in and opens that will for challenge. And unfortunately, the liability then becomes the institutions because they distributed those assets without the will going through that probate process. So for the most part, and certain banks have a certain threshold about how much they will go to in order to enforce the probate rule. But in most circumstances, anything up to after $25,000 Canadian north, 25 to $30,000, the banks will ask you to provide a probated will. So and then the simple reason again there is for the bank's protection, but also when you look at it from the other side, it's also for your own protection, right? The last thing you want is somebody coming up with another will, something maybe you did many, many years ago. This is a newer version. If it's probated, again, it's not open to any kind of challenge. I think I skipped a little bit too far. Okay, there we go. So what happens if you die without a will? Now, again, I can't emphasize how important it is to have a will in place, because if you don't have one in place, it's referred to something that we call intestate, and it means that you have left no instructions as to how you would like your estate to be divided. So you pass away, and if nothing is there, then there's no way anything can be distributed because you have not left any instructions. And so what happens then is that the government will step in and govern how to distribute your estate. And in case of Canada, it'll be governed by Canadian law. They have certain formulas. They have certain ways how they're going to go in and distribute those assets. The problem with this is, it can lead to unnecessary delays, complications, expenses. So I can't emphasize, the whole idea about having this discussion today is to kind of emphasize the importance of having a will in place. Okay, so if you don't have one, my advice to you is, certainly looking at getting one prepared. Um, because the last thing you want, you're not going to be here, but it is going to be your beneficiaries, and I don't think any of you want delays in that process. You want whatever you want to go to your beneficiaries quickly, but if you don't have this will in place, it's only going to delay that process, and then it'll also incur a lot of expenses that are not necessary. So we've talked a lot about wills, and one of the things that goes hand in hand with wills and power are powers of attorney. So, we'll touch on to that point now. So what is a power of attorney? We said that the will is one of the most important documents when you die, right? The power of attorney, on the other hand, is one of the most important documents while you are alive, right? So what is this power of attorney? A power of attorney is a document that allows you to appoint someone that you trust, right? The right to make financial and or healthcare decisions for you in the event you are unable to make them, right? Um, so why is it important to have a power of attorney? Well, this is the document that will be used to access your funds for your well-being if something, in the event you become incapacitated or you're unable to make decisions on your own. So just for argument's sake, let's just say, you end up becoming sick, and you are unable to make certain decisions. Well, if you have the powers of attorney in place, you are allowing those people that you have appointed, the people that you trust, to act on your behalf in order to provide for your well-being, right? Um, the power of attorney that you name will obviously need to present these documents together with any other supporting documents to a financial institution to gain access to your funds. So the one thing the power of attorney cannot do is they can't go and take it for themselves. It has to be for you. So, if God forbid somebody comes in and says, okay, you know what, my father has got Alzheimer's and is unable to perform, he's unable to look after himself. I have a power of attorney. He comes to the bank and presents the power of attorney because he needs to access funds um, for his father or mother's needs. The bank will ask for some supporting documentation. So they will probably ask for a doctor's letter to prove those things, but and that's going to be in addition in addition to the power of attorney. So there are there are very strict guidelines from various institutions to protect you, even though something may have happened to you, and there is a power of attorney in place. The power of attorney cannot be abused, right? Um, so what are the different types of power of attorney? In Canada, there's again generally there are three types of power of attorney, but for this purpose, we'll focus on two powers of attorney. The first is a power of attorney for property. And this is used for making decisions on property and financing. So anything that's related to your physical real estate, your bank accounts, investment accounts, that's the power of attorney that will be used, the power of attorney for property. The power of attorney for personal care is a power of attorney that's used for making decisions that are related to your health, your medical treatment, housing, diet, clothing. And the earlier example that I gave was, let's just say somebody is elderly and they've got some kind of illness where they aren't able to make any kind of decision for themselves, then the person holding that power of attorney will be able to make those decisions. What kind of medical treatment should this person be getting? Where can they stay? Where can they live? The food that they are allowed to eat, the clothing, and so on and so forth. So it's more about their well-being, where you are assigning that power, giving that power to somebody on your behalf to look after you in the event you are unable to make those decisions on your own. So what are some of the things that are contained in your power of attorney? Well, the main thing that it'll contain is the name of the person or persons that can act and make decisions on your behalf in the event that you're unable to, okay? It can be one person, it can be two people. Now, again, I'm not going to get into the technicalities about the joint and several of power attorneys. So that's where I encourage you to use a professional, a lawyer, who will be able to draft these documents. And when they are drafting them, they will give you the different scenarios. So, just to touch, you can have one person as a power of attorney. But what if you want two people as your power of attorney? So, but both have to agree to do something for you. So there could be that extra layer of protection involved in there. But again, in general, you can name one person, two people, whatever you want to name. And the lawyers will be able to guide you as to how to go in and structure that in your individual situation. Um, so again, like I said here, who can you name as your power of attorney? The list is open. Anyone you wish over the age of majority that you trust. And I think that's the key element here, that you trust to handle your affairs. So again, make sure it's someone that you trust quite explicitly to handle your affairs. Your children, if everybody here is older, your children can be your powers of attorney, and that has been the general course and the general thing that I have seen in my practice, where a lot of the times it is the parents name their children as powers of attorney. The other thing that's also very important to do is when you're naming a power of attorney, just like the will, when you came to the executor, you want to make sure that you check with the person that you're naming as power of attorney that they're okay with handling this duty, right? Um, Again, we've seen cases where somebody's named as power of attorney, and when it comes to the time to handle the task, they're unable to handle the task, or they don't want to handle the task. And so what happens in that case, again, the courts will get involved, and there's a process that's involved that'll go through. Now all these things result in delays for your well-being. So make sure that you have a discussion with the person that you're naming as power of attorney, that look, I'm thinking about, I want to name you as power of attorney. Are you okay with that, with taking on that role on my behalf, right? So let's get into a cost thing here. So when you normally go and see a legal professional when it comes to powers of attorney, these wills and powers of attorney, these are done um, together in most cases. So you have your will and you have the two powers of attorney, financial and personal care. That's the general. When you go and see an estate lawyer here in Canada, that'll be the general thing that they will guide you. Now, again, each person is different. So there are some people that are going to have a lot more complicated estates, and that'll require some added layers of, some added layers of more wills in place, like they could be a double will in certain situations. But again, each situation is different. There are several options that are available to you. Number one is what I call the low cost do it yourself approach. These days, we're able to do everything ourselves for some reason, but we fix our own cars, we do our own plumbing. Now that from my case, I don't do a good job at any of that stuff. I have to hire somebody. But you've got those low cost do it yourself approaches. And the average cost for something like that is about $100 to $200. It's done via something called a will kit online. Um, there are those options available to you. Now, in my case, again, as my advice, I highly recommend that you don't use those options. I recommend that you hire a professional and get it done professionally. It's not, it does cost money, but it's probably money well spent. This is not something that you have to do over and over again. It's a one-shot deal in most cases. And if there is updates that need to be done, you can always get updates done via amendments. And those don't cost a lot of money to get done. So hiring a professional, I've seen ranges between $600 and $1,400 for a couple, and this is husband and wife. So you've got two wills in there, one for the husband, one for the wife, and in total four powers of attorney, two for the husband, two for the wife. So again, like I said, I cannot, I will highly recommend that you use a professional to help you with this, because there's a process that they can walk you through. There's an interview process, and there's a lot of legal terminology that sometimes I myself don't understand, and this is their job. So let them handle that for you, and you will be able to ask questions directly to them for any kind of clarification that you want to get. So we now know the basics about the wills and powers of attorney. I'm hoping that I've given you the basic understanding of what these documents are. What should you do now? So number one, if you already have a will in place, excellent. That's great. Um, Review the will, right? Review the will, review the power of attorney. Make sure that there are no updates required. So I've seen cases where a will was done such a long time ago where the parents had two children, and all of a sudden now they have three children, right? So they had never updated after they had their third child. We've seen cases where the executors are passed, or or maybe even one of the beneficiaries has passed, right? So my rule of thumb is, on your birthday every year, you pull this document out, take a quick read, see what's changed. If nothing's changed, put it away. At the very least, do it every 3 to 5 years. Number two, and again, this is very important. And so the first part is review it. Number two is inform. Inform your children, your beneficiaries, your executors, where you keep these wills and powers of attorney. So where do you store them? Some people keep them at the bank. Some people keep it with the lawyer. Some people keep a copy at home. Wherever you keep it, just make sure somebody knows where to find it, because when someone passes, it's an emotionally challenging time for the family members, and at some point then they're going to have to sort out your affairs. So if you have told them, listen, this is where my stuff is kept, then it'll make it easier for them um, to execute on your wishes. At the end of the day, remember, whatever is in the will are your wishes. So if you want somebody to go in and execute on those wishes for you, then let them know where those documents are. Number three, reconfirm. And when I say reconfirm, check again with your executors, your power of attorneys, that they're still alive and that they're okay to perform those duties should something happen to you. So normally, what we normally do is in our cases is we name some friends or people that are the same age as us as our executors, right? And sometimes they pass before us. So, or they have now also become they're also elderly, and they might not be able to perform those duties. So, number one, check to see if they're still around. Number two, very important, again, reconfirm with them. Say, look, you're my executor. Are you okay with handling this duty if something happens to me, right? If not, then you need to get that updated. Now, number four, get organized. Organize yourself so that when you're gone, people know where things are. And again, when I say get organized, you don't have to go through this major process of, sorting out every single thing. I think that's, take baby steps, one step at a time. One of the things that I recommend to all of our clients is have something called an estate organizer. Could be a simple folder, where you enter information, type it up on a computer, or write it in a notepad. And the information that you're going to put there is, things like, who are your advisors? Where are your bank accounts? What kind of assets, liabilities do you have? Where are your insurance policies? Do you have a safety deposit box? Where is the key? Um, and keep this document in a safe place. And what I would suggest that you do is you may also want to take a copy and put it together with your wills. So when somebody opens your will, they're going to go in and see this document in there and they say, oh, okay, the bank account is at BMO, or the bank account is at the TD. My insurance policy is here. My safety deposit box is here, and here is the key. So this will make it very easy, or it will make the process a little bit simpler for the executors and your beneficiaries to settle the estate. The faster they can settle the estate, the faster this process gets completed, and they are able to become the benefactors of the money. Now imagine if there was no document and they are now scrambling and saying, okay, I know my dad or mom used to bank at Scotia, but I don't know what branch it is, right? Or I know there was a safety deposit box and it was with the TD and it was in, Richmond Hill or in Markham. Well, how many branches are there? And now you have to go on this goose chase, on this witch hunt, trying to find where the safety deposit box is. And when you finally figure it out, there's a whole bunch of things that they have to go through in order to get through that process. So if you direct them where it is, it saves a whole bunch of time. It saves a whole bunch of money, from your estate, so that more can end up going to your beneficiaries. This is another important point, and I think it's point number 5: is have a family discussion, right? A lot of the times, from a cultural perspective, what I've noticed in my practice is that we don't take the time to sit down with our children or beneficiaries and have this discussion, right? Um, if your beneficiaries are adults, sit down with them, tell them, look, this is what I have. You don't have to give full details if you don't want to, right? You don't have to give financial numbers that, I've got X amount, I've got X amount. Say, look, I've got a certain amount of things, and these are my wishes. So when something happens to me, I want to be number one. It's all in my will, but there are certain things that I want you guys to know. So my will is kept over here. I want to be buried in this cemetery. I want you to do this after me for Sawab Jariya, if you can. So let them know of those things, have that discussion so that when the time comes, they are aware of what your wishes were. There's no confusion and say, oh, you know what, my mom and dad wanted this. But after you've had this discussion with them, my advice is always put these things in writing, right? Put it in writing so that there are no disputes down the road, right? There'll be circumstances where, you know, the father is not well, and he calls all the kids over and says, okay, listen, I'm not going to be around. So when I go, I'm leaving everything to your mother. And once something happens to her, she will then distribute to you, right? And at that time, everybody's in agreement, everything is fine. Something happens to the dad, and all of a sudden, when the mother is supposed to get everything, the kids come in and say, no, but I want my share, or I want my share. And then you start to get into these disputes. And that's what you're trying to avoid by putting things down in writing. So lay out your wishes. And if you want to discuss it with them, even better. Like I said, you don't have to go in and give them specifics. You can just say, look, I've named you in my will. You are my beneficiary. You are my executor, or I've named you as joint beneficiaries. And this is how it is. This is how I want things done after I'm gone. And then, of course, it's in writing. So that's the supporting document. Now we come to the other part. What if we don't have a will and a power of attorney? Well, I'll tell you, now is a good time to start. Okay. So, begin by sitting down and thinking what is it and how you want your estate to be distributed, right? Then have a discussion with your family, your children, and tell them, look, these are my wishes. Figure out who you want, to be the executor of your will, who are going to be your powers of attorney if something were to happen to you, and have a general discussion with them while you're okay, so that they know that, oh, okay, this is what my father or mother wanted, right? If something were to happen to them, if they haven't told them anything, then they're kind of flying blind, right? They don't know what it is that you might have wanted. Once you have all of those things in place, then get in touch again with a professional and get the proper documentation prepared. And then, of course, the last step is, once the wills are drafted and you have signed them, keep them in a safe place and inform your beneficiaries, your executors, where they can find these documents, either in your home or at the lawyer's office. A lot of the times what happens, the lawyer that prepares these documents will have something in a will bank, and they will keep those wills in that will bank. But again, always have a copy for yourself, and keep one in the safety deposit box or at home. So I think that concludes, for the most part, what I wanted to say. I think we're right at the 40-minute mark there, which was the plan to have for the discussion. And at this point, what I want to do is allow an open floor discussion for any questions or concerns that you guys have had.
Very well timed and lots of information, lots of stuff for discussion. I think you covered a fair bit of ground. Before we go into, there are some comments or questions in the chat. We'll go to that. But I think just as a reminder that Muhammad has talked about the wills, the power of attorney, and everything in general detail. You will also need your accountant if you want your financial planning done, estate planning done. You need an expert in that area. So Muhammad has only talked about giving you an overview of the will, the power of attorney, the things you should keep in mind. Remember that if the estate is planned properly, you will be able to minimize certain taxes which arise on death. People think that, there are no death taxes in Canada. Well, there are taxes on death in Canada. But again, you'll need to talk to your professional advisors. And we have certain other professionals in the audience, and maybe they can comment later on if they choose to. So there's a question from Naushad Kasmuli. What, in your opinion, is a large estate?
Yeah. If I'm going to put a dollar value on anything large okay, so when we're talking about substantially large estates, anything north of $2 to $3 million would be a fairly large estate to settle. But I would say, you need to have a will in place regardless of the size of your estate, unless you're a person that says, look, I have absolutely nothing. But even then you have certain wishes, right? So put those down in a will. So to answer your question, anything north, I would say north of 100,000 is something that you would still look at. But I don't want to. If you're asking for a specific number and what we consider a large estate, then anything north of, I would say north of $1 million is a large estate.
Wonderful. Okay. Also, keep in mind that, those who already have residences here, especially in Toronto area or Vancouver or wherever, with the way the real estate prices have gone up, it's very easy for these numbers, to go way out of line. Sometimes we don't even realize how wealthy we are on paper.
Exactly.
Okay. All right. Thank you. Thank you. Second is, yeah, we talked about the large estate. Muhammad, you can see the chat, right?
I am trying to.
I don't mind reading it.
Yeah, if that's okay, then I don't have to.
Yes, to and fro, right?
Yeah.
So you can just go down the chat, and before you do that, a very quick question which someone asked me directly was regarding handwritten wills. They do not have to be witnessed or drafted. Handwritten obviously doesn't have to be drafted by a lawyer. You touched on this. Can you just comment further on that, please?
Yeah,
if you can.
To me, they don't have to be. They don't have to be witnessed. It is your wishes, as far as I understand. That's why they call it the holographic will. It is your wishes. But again, the day and age that we're in, it's open to too many challenges. Like I said, it's very. I have yet to see. I haven't seen any in my practice so far. That somebody has a handwritten will. And again, like I said, it's something that we encourage everybody to avoid, unless you know that for a fact I've got absolutely nothing, and this is my wish, so here you go, right? But I would definitely go in and get something that's typed up and in a proper document form.
You're going through the chat, right? Or shall I read them?
No, can you, sorry, because every time I do this, it's taking me.
Okay, no problem, no problem. Does the executor have to be paid? Does he charge fees? And I know there's something allowed for that. Go ahead.
So the executor is allowed to take an executorship fee of up to 5% of the estate.
Excellent, thank you. Which documents will be valid, print or electronic versions? When is it advisable to have a trust? Again, do you want to touch on the trusts?
Yeah, I'm going to stay away from the trust, because now you're kind of getting into a very different area. So trusts have got a lot of, there are different kinds of trusts that can be formed. There are spousal trusts, there are inter vivos trusts. So again, we'll stay away from that because it's kind of out of the scope of the general essence of this presentation. But sorry, what was the other question was about print or electronic?
Yeah, these days, there's so many documents in electronic form.
Yeah.
And you can sign documents electronically, but
yes. I don't think so. For the most part, your wills have to be signed in person. I don't think they've come up to the point where it is, even if you do everything electronically right now, the lawyer will still call you to the office to do the signing in front of them. I don't think they're at the stage where electronic signatures are acceptable. But I could be wrong on that because it's, again, a changing situation. For the most part, I'm pretty sure that the lawyer will call you and you will have to sign in front of them, because they're the ones preparing the will for you.
Okay, excellent.
And if it's not an original will, then you will have to get, so, normally we don't have 20 copies of our will, right? We have 1 copy or 2 copies. But if you have the original, then the institutions will ask for a notarized copy of the original. And when you get that notarized by a notary, and they will accept those as a notarized copy of the will.
Excellent. Would you recommend passing copy of your will as updated from time to time to your beneficiaries?
Yeah, I think that's more of a personal choice. There are some people that, they want to disclose everything. And if you're at that level, then why not, right? If you have a relationship with your family members where you're comfortable doing that, then by all means, yes. And if you're not, then, you can at least tell them, you don't have to, give specifics, but you can tell them in general that this is what is going to happen after I die.
Right. Okay, and you touched on something early during your presentation, important to have a discussion, even in general terms, with the family members. And just comment on that. It is very, very important, especially if you're leaving unequal portions to your children, because if you don't discuss them ahead of time, then after you're gone, there will be fights and there may be disputes and there may be whatever. So if you're leaving unequal portions and whatever else, or leaving a large amount to a charity.
And that's exactly what I was going to say. Sometimes what happens is, the person may feel that the children have done very well for themselves, and that individual would like this money to go into a specific charity, right at their death, so that it can continue to provide for them while in their next world. So and what happens there is, if you don't tell that to the kids and then they read it, it becomes kind of a little bit of a sticker shock, right? Oh, my dad or my mom, they didn't leave me anything, right? But if you explain it to them before you're gone and say, look, guys, you've done well for yourselves. In some cases, you've got more than I have, right? You're looking after me, right? Or so I have this little thing, and this is what I would like to do with it. I hope you guys are okay with it. I mean, you don't have to really justify it to anybody. At the end of the day, it's your money. But I think what will happen there is it's showing that, you've got that, you're avoiding any kind of dispute. And in your case, when you mentioned about the inequality that comes in, yes, that can be the inequalities can become quite challenging. They can create family rifts. They can result in significant expenses on settling those things. So yeah, you want to try and do this thing. You want to try and have it clearly laid out so that you avoid any of those issues down the road.
Excellent. Are you comfortable commenting on double wills or separate wills for your estate?
Yeah, so what I will only say is double wills come in for people that have got holding companies in place. So a lot of the times when you have holding companies or corporate accounts and things like that, there's shares involved, and those can bypass the probate process. But that's all I'll say right now on that.
Or sometimes you have foreign assets overseas.
Yeah, so when it comes to foreign assets, what I will suggest is if there are physical assets in every country, then you get a will done locally over there. I know even in Canada, for people that have got assets in Quebec, we tell them to have a will done there because you're in the same country, but there's two different jurisdictions, right? So my advice on that is if you have dealings in other countries, physical assets, then, get a will done over there so that when it goes through that probate process, it's done locally and you're not using a will from here.
How many original signed and sealed copies of the document should be asked from the lawyer? Well, I guess.
I would probably cap it at 3, if anything. Like then you're going on the overkill. Normally they'll give you 2, but if you really want to say, give me 3 because I want to give one to the kids or something like that, then that's where I would, because you can always get them notarized, right?
Yes. All right. Can we have multiple executors?
Yeah, and I think I touched on this earlier, or maybe I didn't mention it in the powers of attorney. Yes, you can have multiple executors. And again, I won't get into the technical details of this. So you could have an executor that, you could set it up where, let's just say if you have 3 children, they have to act jointly and severally, meaning one of the executors cannot do something without the consent of the other. They all have to act together, right, in agreement, and then move forward. Similarly with the power of attorney. So you can have joint executors, yes.
The other thing I've seen is you have your named executor failing womb. You have a secondary executor. Correct. That avoids the question of, the first one,
yes,
for whatever reason, doesn't want to act.
Correct.
Or has passed on or whatever. Go ahead.
Yeah. And so that would also come in when you name multiple executors in there.
Okay, question on probate taxes. How do you minimize them? Do you want to comment on that, or is it something too special?
It's always the tax. No, it's always the tax.
Nobody wants to pay taxes.
Look, there are many. Again, and I don't want to comment on specific things here because each situation is different. Each individual's circumstances is different. There is no cookie cutter solution that can be applied to everybody, right? The one thing I will suggest that you do is between you and your spouse, at least that first layer, have things in joint name. So you bypass the probate process. If you have things only in your name and she has things in her name, if something were to happen, it has to go through the probate process because now that person is no longer there. It goes into the estate and so on and so forth. If you have, again, and I encourage everybody when it comes to bank accounts, have it joint with rights of survivorship so that those accounts are not frozen upon the death of the first person. Always have those things in place.
Can you, excuse me, can you mute yourself, please? Thank you.
Sorry, I lost my thought there, but yeah. Sorry. So in terms of being, having the joint with rights of survivors, so you can avoid the probate at that time, right? By having it a joint, you're avoiding probate tax the first time around. If you don't have it joint, you're going to pay probate the first time around, and then you'll pay probate the second time around. Okay. The other thing that you can do is, if you have RSP accounts, TFSA accounts, we normally name, and you're married, you normally name your spouse as beneficiary. And then there's something called a contingent beneficiary. So what the contingent beneficiary is, if something happens to my spouse and she's named as beneficiary and something happens to her, then by naming a contingent beneficiary, that does not become part of probate, because what goes to probate is anything that goes to the estate, right? So if it doesn't go to the estate and it goes to the beneficiary directly, it bypasses. It doesn't come into that probate calculation. Life insurance policies. If you name an individual, you can bypass some of the probate, right? If it goes to your estate, however, it'll be subject to probate, right? Now, remember, again, I encourage everybody to take advice on this all the time, because sometimes it's fine to avoid probate, but you also have to look at why you're doing certain things. Are you creating a bigger problem down the road for yourselves, right? So the classic example, I hear, "Apa nam nakide," and they're nam nakide, bacha no nam nakide. You add these names in. So, Nazmul, you give an example about real estate, and everybody's real estate is worth a decent amount right now. So, by adding your kids now to the real estate, are you potentially creating a problem down the road, right? Because to avoid the probate process, what you've now done is you've made them joint owner today, right? So any capital gain that accrues on that, your principal residence is not subject to any tax, right? But now it's not only yours, it's also theirs, right? So just be careful. By trying to avoid the 1.5%, you don't end up paying 10% tax, right? That's the message that you want to kind of get out there.
And it's really, we have to keep in perspective. On $1 million, 1.5% is $15,000.
Yeah.
And to save the 15,000, is it worth taking on all that additional hassle or whatever?
Yeah, because remember too, like as you add things, you are exposing yourself to a lot of things, right? You're technically, by adding a name on something, you have parted with that portion of that asset, right? It doesn't become yours anymore. You have opted to go away with that portion. Now, from the flip side, that could potentially come into play on the marital side of somebody else, right? So again, I don't want to get into the technicalities, but the message is, for trying to save that 15,000 in probate tax could cost you a lot more in the future, right? By doing that.
Muhammad, you kindly agree that you'll stay on. I have many more messages, so we'll stick to the point and okay, so that we can answer as many questions as we can. Okay, someone has an Islamic will. Is he not covered, or is he covered, or whatever? Please just explain what the position is.
Yeah. So again, I said this at the beginning. I'm not an expert when it comes to Islamic will. We do have experts in the field, and I would urge you to consult those people. The Islamic will, it has to, obviously, once the will is approved and it's an approved format, there are ways to make a will Islamic, okay, as far as I'm concerned. But again, I'm not a religious authority. There's a portion that's allotted to the 1/3 portion can be used to do equalizations. And I've heard Molana talk about this several times, that the 1/3 portion is yours and you can give it to anybody. So you could use that for equalizations. But again, I want to stay away from, that's not my, it's not my expertise. So I would urge you to get in touch with the right people for that.
If the questioner is asking, an Islamic will, is it a legal Canadian will? Yes, it can be. Right?
Yeah, it can be. My understanding is it's not going to say this is an Islamic will. It's just going to be a will that you have prepared. And even when you go to the lawyer and say, listen, I want an Islamic will, right? The lawyer will tell you, well, what is the Islamic will formula that you want to come up to, and how can we get close to that, right? That's how they're going to probably direct you. But at the end of the day, we're not in an Islamic country, and so you don't have that Sharia law per se that will automatically go in and use the distribution of assets by Islamic will format.
Okay. Executor, does he have to be a Canadian citizen?
Okay, that I'm not 100% sure, but I think 90% sure that yes, you want somebody over here, because the last thing you want is somebody from another country handling your affairs over here. It becomes very time consuming. It's very, very, very inefficient to do it. And also, because they also have to prove certain things about their status and all that. You want somebody that's based out of where you live in order to execute on your wishes.
Okay. A will drawn about 25 years ago by a lawyer out of town. The individual has a copy with him. Does he have to get the original from the lawyer, or does he have to notarize it, or what's the process?
Yeah. So if you have a copy of your will, I would definitely get you to carry notarized copies of the will, because when something is notarized, someone is certifying it that it is the original. And when you go and present it to the bank, or you have to enact that will, or you go in and put it in force, they will definitely ask you for a notarized copy. Now, there is something called the will bank, where all the wills are then gone and stored, right? So they will take that copy and then go in and see that it matches. But this way, somebody has seen the original and they've certified it, so you're in decent shape.
Great. Question from England. In other jurisdictions, signature of testator, that's the person doing the will, must be witnessed and signed by two witnesses at the same time. Handwritten will is an exception in Canada. You touched on this, but maybe you can just repeat the response.
Yeah.
Holographic will.
Yeah. So again, with holographic will, it's just something that you write on a piece of paper in your own handwriting. There's no witness. There's nothing, as far as my understanding goes. And if you do something that's properly prepared, yes, it needs to be. You'll go to the lawyer's office and you will sign in front of the lawyer, and they will witness all the documents for you.
Right.
But again, I'm cautioning here. The holographic will is not recommended, because it can open it up to a lot of challenges down the road.
Yeah. Okay, I believe I've gone through all the questions or comments in the chat. Just a couple of points, if I may. Muhammad, do you want to talk about corporate executors, the services provided by bank and trust companies?
Yeah, sure. I can touch a little bit on that for sure.
Just briefly, yeah.
Yeah. So what happens is, and we're seeing a lot of that right now. So when somebody passes, they have named it. You can name an individual as your executor, right, to handle your estate. Now, there's a lot of work that's involved. Sometimes there can be a lot of work that's involved in handling all of these things, right? And so there are professional companies out there. They're called trust companies. All the banks have them. So there's BMO Trust, Scotia Trust, RBC Trust. They all have them, TD Trust. These people will come in and handle those things on your behalf. And the process, the way that works is you name them in your will as your executor. They can work with your beneficiaries, they can work without your beneficiaries, but essentially what they're doing, it's like a white glove treatment. Once you pass, they take over, and they can be so involved that they'll go and sell the furniture, they'll dispose of the house, then so on and so forth. And when the time comes, sit with your beneficiary and say, okay, this is all done, the tax returns are filed, here is the distribution, and here is what you're getting, right? So the beneficiaries in that case don't have to do anything. You are just there. These are the guys that are handling it, right? And of course, for that, there is a fee, and the fee ranges. So none of them I don't think any of them take the 5% fee level on that, but it's somewhere between 2.5% to 3%, depending on the size of the estate. Now, if the estate is very large, then that fee ends up being lower because it's a percentage, right? So it could be about 1% of the overall estate. But yes, that's a good point that you brought up. We are finding right now that a lot of people, when it's a complicated estate, if there's multiple holding companies and so on and so forth, it can become, it can become a lot to handle for a grieving person in some cases, or they might just not have the expertise, right? And I'll tell you what happens a lot of the time is, people start doing this, and even we've seen it with, the kids that are inheriting this money. They start doing these things and they're like, oh my God, this is crazy. This is too much work. Let's just go hire somebody to do it, right? So you as the individual have that choice to go and say, and again, when I say have this discussion with the kids, so let's just say you have the discussion with the kids and say, look, I want to name you as my executors. Are you guys okay with it? Right? And they're like, oh, mom, dad, this is going to be a lot of work. What are other options? Well, the other option is let's hire a trust company to do it for us, right? And a trust company, one of the benefits is you're not hiring an individual, you're hiring a company, right? So that executor never dies because the company will be around, right? And so it's somebody that is working at that company that'll continue to handle that case. So, so we've seen people hire lawyers to be their executors. But again, lawyers too, they pass away, right? So there's no continuity there. They'll hand over the file to somebody else. So that's a good point. Yes, you can use trust companies, and it's a common practice in today's day and age.
Yeah, for sizable assets, as you say, it's definitely worth considering.
Yeah, I wouldn't say just sizable. I would say if you have a complicated estate, right?
Okay.
If you are, say you're a business owner, you have multiple entities, and it could be a little bit of, there could be a lot of moving parts involved, right? If you have partnerships here, if you have, and a lot of the times when you're at that level, you do have legal advisors involved. So, those things are looked after, but some people miss this last little part where, well, everything is there because I'm the working person on this. I know the whole moving part. What happens when I'm gone? Who's going to handle all of these things, right?
Right. And I think the other key point to that is they are impartial. They're not a family member or a friend or somebody.
Correct. So now, from that perspective, they are professionals. So they are responsible, in most cases, they are responsible to the ultimate beneficiary of this money, so that, they're liable. They have to do everything by the book, right? So even when it comes to getting the whole list of assets, right, they will go and value every single item by the book. So if there's jewelry involved, if they will get valuations, all of those things done, right? And they will they will then do the probate tax. They will do all of the other stuff, and then they will file the final return on your behalf.
I have a question, if I may.
Yeah.
Who is this?
Nasser.
Who is this? Okay, go ahead. I didn't see you raise hand, but go ahead.
Just a quick question is, I have a will, and the lawyer, it's been a very old will, and the lawyer has passed away. And after that, I have the original one where if I want to make some changes, can I make it by hand, handwritten on a certain portion of it? And then will that be valid?
So thanks for your question. That's a good question. Number one, your lawyer has passed away, but your will doesn't pass away because it's your will, right? So as long as you have an original will, you're in good shape. Now, when it comes to making changes on that will, you can make we call them amendments. So you can make amendments to the will, and those you need to take that back to a lawyer to get it properly inserted into your will. You can't just go in and handwrite something and say, okay, this is my updated version, right? In handwriting. Now, having said that, things change every day, right? Something happens here or something happens there, and so I've encouraged our clients or friends and family members, and including myself, I put something called a letter of wishes, right? Now, a letter of wishes is just a standard letter between me and, not really, it's not a real legal document per se, because it cannot be enforced in court. It's just a letter to my kids or something saying, look, if something happens to me, then these are some of the things that I would like you to do. These are my wishes. Whether you fulfill them or not, it's up to you, right? But it can't be enforced if it's not in the will. They don't have to do it if it's not in the will.
Okay.
So if they were, what you said your will was how old again?
It's pretty old, like 10 years old.
Yeah.
And anything, I need to change a lot of things. And I was told that I can write and have it witnessed. That should be sufficient. So that's the reason for my asking the
Yeah,
question.
no, I would definitely, if it's that, if you said there's a lot of updates, then get a refresher done, right? Get a refresher done. 10 years, a lot has changed, I'm sure, in your case.
Yeah. I
And
have, in fact, marked changes in there, and I have witnessed it. I was
yeah,
just thinking of getting it notarized, but how would they notarize something that
yeah, yeah. No, what
I?
you need to do is the term is called amendments. Amendments are cheaper, but if there's
Yeah.
a lot of changes that have to be done, then just get it rewritten to the current time, right?
So I can go to any lawyer, any
You
will
can go
lawyer,
to,
and get.
yeah, any estate lawyer would be able to do that
Uh-huh.
for you.
Okay. Okay. All right. Thank you.
You're welcome.
I think the other thing to remember is, the laws change. There are case law all the time coming through. So it's always better to go to a professional to get up to date, situation. So anyway, that's good. Great. Okay, I think we've covered a lot of ground. I don't see any other questions or raised hands. If I have missed anything, this is your last chance to ask the question. But otherwise, I will just remind you that next week we will have a psychiatrist coming to do the presentation for us. And I'm sure you would, well, I hope you'll want to join us and participate in the discussions and the presentation. Muhammad, you did exceptionally well, very well done, a lot of ground covered. This is a subject, very important, dear, close to many, well, all our lives, to everybody. And, lots of good questions, which you answered very, very aptly. Thank you so much.
No, again, if I can just close up here and share my thoughts one last time, thanks again to everybody. I think you have close to 35 people or 33 people online taking the time on a Sunday afternoon. This is normally nap time, right? 2 o'clock Sunday afternoon, but
We are not all seniors. Come on.
I'm driving whilst I'm listening and ask questions.
but no, it was I mean, real pleasure. Thanks again for giving me this chance. And again, if the things that I want you to take from today's presentation is just look at these things, have the discussion with your families about it. Visit if you don't have these things in place, then try and get that process going. It is a difficult discussion to have because again we're talking about to our family members about leaving, right? But at the end of the day, that's reality. It's something that's going to happen to all of us. And I think from your perspective, if you have worked so hard to gather what you have and it's for your kids, then you want them to get it as quickly as possible once you're gone, right? So what better way than to have all those things set up so that it happens? I've seen estates take 5 to 7 years to settle because the stuff is not in order. And I don't think any of us want that to happen, right? If something were to happen to us.
And for those who are still in the meeting, just a final word and a reminder that yes, all this information is very, very useful, but also you need, in addition to a lawyer to draft your wills and powers of attorney, you need a good accountant, a estate planner, you need those people. And to make sure that you minimize your taxes, you have everything in order, you thought long term as to what's going to happen to the people you leave behind. Have you made enough provision, whatever? And that is all your estate planning and your financial planning. So yes, it's not a one professional's job to do all this. I'm not sure if you can find such a person, but there are multiple professionals involved. Muhammad, any comments?
Yeah, no. Again, to me, look, getting professional help, or involving a professional, it costs money, right? And that's just the way it works. But I do encourage everyone to reach out to the right people, get the advice. And it may come out saying, oh, everything is fine, you're in good shape, don't worry about it, right? But for sure, work with all these people, especially the more complicated your situation. Yes, I definitely encourage you to get the help from the professional guys, because they may come up with something that will help you minimize that tax burden, right? Or a simple thing like getting the estate sorted out faster, right? So there are several things, and these people do have those tools available to them. No one's going to help you completely avoid taxes. It's not, we have to pay something. We know that, right? But if we can minimize that amount with the things that we are allowed to do, then yes, it's a big plus, right?
Excellent. There is a request for your email, your contact information, but we'll chat about that separately.
Sure.
Okay. Thank
Yep.
you so much. Thank you, everybody. And hopefully we'll see you next week.
Okay.